This is intended to provide an opportunity for learning and understanding around the Cowichan Tribes decision. I'm really pleased to introduce our legal experts that are here with us today to help us understand this precedent-setting decision and the implications that it has for us as local governments. On our panel today is David Rosenberg, a distinguished member of the legal community in King's Council, who served as a senior legal counsel to the Cowichan Nation within this case. He has been a senior lead counsel on several major appeals to the Supreme Court of Canada in constitutional, civil, criminal, and First Nations cases. David was lead counsel for the Cowichan Nation at trial on the successful appeal to the Supreme Court of Canada. We also have Robin Junger with us, the legal counsel with Macmillan LLP. He's a lawyer with over 30 years of experience working on environmental and Indigenous law issues, both in private practice and in senior roles within government, including as Chief Provincial Treaty Negotiator and as Deputy Minister of Energy, Mines, and Petroleum Resources. We also have Reese Harding with us, partner with Anderson Young. His practice is focused on local government law litigation, but includes judicial review, administrative law, Aboriginal law, assessment and taxation law, natural hazard risk avoidance, governance, and conflict resolution. Welcome, and thanks to all of you so much for being here with us today. To begin, I'd like to ask David to provide an overview of the case, and then I have a few questions for our panel before we'll open it up for questions from the floor. Thank you. As you feel comfortable.
I'll stand up there.
Great.
Try to remove the laptop.
We'll move it over. Last time I told somebody they could close it, and I got in trouble with that.
Oh.
We'll make some.
Thank you. Thank you, Jenna, and thank you, Gary McIsaac, for inviting me, and thank you for the Union of BC Municipalities for having me come here today and address this topic. I also want to acknowledge that my co-panelists, Robin Younger and Reese Harding, for their cooperation and working together in preparing this presentation. Now, I'm going to approach this more as an overview or an opportunity to explain what happened in the Cowichan Nation case, which for those of you who are interested in the legal citation, it's cited at 2025 BCSC 1490. It's a decision that the reasons were handed down on August 7th, 2025. And for those of you who have the time and inclination to read the reasons, they're 3,728 paragraphs, almost 1,000 pages long. But I do commend it because there's a very interesting description of the settlement of British Columbia, and the reasons themselves are very rich in history, both written and oral. There were expert witnesses in the fields of anthropology, history, cartography, ethnohistory. There were oral historians from several First Nations who came and gave the oral history of their peoples. And Justice Barbara Young, who rendered the reasons, goes through a lot of that history and the expert opinions in great detail. I want to focus in today in talking to you about the issues that you may find of interest. For example, one of the central and interesting issues in the case is whether or not Aboriginal title and fee simple interests can coexist. Another interesting issue was what happens when the court finds Aboriginal title and it exists over public and private lands. What's the appropriate remedy with respect to finding Aboriginal title over public lands? As many of you may know, those who are familiar with the reasons and the background here, the trial judge declared that the title that was held by Richmond and Canada in the area where she found Aboriginal title, she found those titles to be defective and invalid. So what we'll get to at one point, hopefully in the discussion today, is what that impact will have on private property interests. By way of background, just general background about the case itself, the case was brought by the Cowichan Nation, whose membership was comprised of the members of 5 bands: the Cowichan Tribes, the Chemanis, the Penelakut, the Halalt, and the Liaxin. The Cowichan Nation brought the case originally against the Crown, seeking land recovery and fishing rights on the Fraser River. They claimed that an ancient village of about 1,846 acres of what is now in Richmond on the Fraser River was their ancient village, and they referred to it as Cluctinus. The claim area itself, that 1,846 acres, was comprised of several different kinds of land, and that's what makes this case so interesting in some ways. Some of the land within the claim area was what we call legally submerged lands. There were municipal lands that belonged to the City of Vancouver. There were port lands that belonged to the Fraser River Port Authority, and there were private lands that were held by private individuals. But I will stress that those private lands were within the claim area, but the landowners were not parties to the litigation. And we'll come back to that because that's an important distinction about what the court decides in this case. I mentioned originally the case was brought against the Crown, but the Musqueam Indian Band and the Tawasin First Nation applied to be joined in the litigation, as did the Vancouver Fraser River Port Authority. The trial took 513 days, probably the longest trial in Canadian history. And the 2 central issues, or most important issues to be decided in the case, were whether or not the Cowichan Nation had Aboriginal title. Many of you know the test for proof of Aboriginal title is whether at the date of the assertion of Crown sovereignty in 1846, they exclusively occupied the claim area. The other central issue was whether or not the Cowichan Nation had fishing rights on the south arm of the Fraser River. And as many of you will know, that test for determining whether or not Aboriginal rights like fishing rights can be proven is whether or not at the time of contact, the practice of fishing on the south arm of the Fraser River was integral to the distinctive culture of the Cowichan Nation. The time of contact in this case, and in most cases that have proceeded in British Columbia for court purposes, is 1792. Well, at the end of the day, after the trial judge reserved her decision and analyzed the evidence for about 20 months, she came back and made 6 declarations. And I'm going to go through the 6 declarations and explain why they may be important for our purposes today. The first declaration was that the descendants of the Cowichan Nation have Aboriginal title to a portion of the lands of Cluctinus. She concluded that of the 1,846 acres that were claimed, about 800 acres were subject to Aboriginal title. The second declaration she made was that the Crown grants of fee simple interest in the Cowichan title lands unjustifiably infringe the Cowichan Nation Aboriginal title to those lands. The third declaration she made was that Canada's fee simple titles in the claim area, in Cowichan's fee simple titles in the area where she found Aboriginal title and Richmond's fee simple titles in that area are defective and invalid. The fourth thing she found was that Canada owed a duty to negotiate in good faith reconciliation for some of the lands it held. And fifthly, she found that British Columbia owes a duty to the descendants of the Cowichan Nation to negotiate in good faith reconciliation of the Crown-granted fee simple interests held by third parties. And the Crown vesting of the soil and freehold interest to Richmond and with Cowichan title is a manner that must be dealt with consistent with the honor of the Crown. The final declaration she made, the sixth one, was that the Cowichan Nation had an Aboriginal right to fish the south arm of the Fraser River. It's interesting, as I went through those 6 declarations, what the judge did not decide and what was not an issue, which might be equally important for our purposes. There was no damage claim brought in the case by the Cowichan Nation, and there was no claim brought against private property holders. There was no declaratory relief sought with respect to the interests of those private property holders. And we'll come back to that. I should tell you that since August 7th, there have been 7 notices of appeal filed in this case, and there are only 7 parties, which tells you that every single one of the parties had something to appeal about. I want to give you an example of some of the evidence that was heard in this case, because so far I've sort of just dryly been going through what the reasons are, but I want to try and capture some of the interesting background. And I could start by saying in 1824, about 200 years ago, when European explorers first came to the south arm of the Fraser River, which interestingly was called the Cowichan River, that's what it was designated on maps, they came upon a village that was comprised of 108 longhouses along the shore of the river, 2 rows of 54 longhouses on the river. And when they went ashore, they noticed that it was made of post and beam construction. It turned out that that village was the place where the Cowichan Nation traveled and had been traveling for hundreds of years and continued to travel in the spring right up into the right until the late 1900s to catch their winter supply of sockeye salmon. But picture 11 communities, because that was the ancestral historic communities of the Cowichan Nation, 11 communities on southeastern Vancouver Island and the southern Gulf Islands, taking the wall planks off their own houses in their winter villages, assembling them on their canoes, making platforms into catamarans, piling their possessions and their families onto those catamarans, and by the thousands coming to the mouth of the Fraser River, landing at their summer village place, taking those wall planks off the canoes and assembling them into the post and beam structures that were standing along the shore. It must have been an incredible sight to see back in the 1800s when that was going on. They traversed the Georgia Strait or the Salish Sea, and they stayed there for the several months in the summer till they returned back to their winter villages with their food supply. So the question is, what happened to that village, that ancient village that was their summer village where the whole nation congregated each year in the summertime? Well, to put it simply, the land was sold out from under them to land speculators. And in fact, one scandalous piece of our history in British Columbia is the first Chief Commissioner of Lands and Works, Colonel Richard Moody, whose job it was to protect those lands for the purpose of creating reserves. He surreptitiously bought some of those lands himself through a land agent, and he left the country and continued his purchases of land for speculative purposes. Well, when the Cowichan found out about this in the 1870s, they complained to the Indian Reserve Commissioner Gilbert Sprout that their ancient fishery had been taken from them. And he said to the Lieutenant Governor, what are we to do about this? Now that's 150 years ago. And one suggestion was perhaps it should be purchased back for the Cowichan Nation. But nothing was done. The Cowichan followed their complaints up with 2 trips to England to petition to try and get their land back to the king. They went to the courts of British Columbia to try and get the courts to rule that they should get their land back, but the province of British Columbia denied them a fiat, which was what was required, permission to go to court, so they couldn't go to court. Well, eventually, a portion of these lands came into the possession of the City of Richmond through tax forfeitures. The foreign landowners and speculators who owned this land didn't pay their taxes, and under the governing statutory regime, the land came back to Richmond, and that becomes important later in the judge's reasons when she looks at the relative importance of the land between Canada and Richmond or the First Nation. One more point I want to turn to that I think will be important for our discussion is a finding by the court that the conveyancing or transfer of the lands from the Crown to third parties, which happened between 1871 and 1914, was both statutorily and constitutionally invalid or illegal. The judge wrote hundreds of pages about this, but I think I can distill it down to this one central idea. These lands were settlement lands, and settlement lands were supposed to be put aside for reserves for the First Nations. And when British Columbia entered Confederation, Article 13 of the Terms of Union governed the conduct of British Columbia, and the court has held that that included that these lands had to be preserved for reserve creation. So the statutes, if you like, that allowed for the transfer of those lands exempted settlement lands, and the Terms of Union didn't allow British Columbia to convey the lands to third parties constitutionally. Now, there were some novel issues that were decided in the case that were novel in the sense that no court of law in Canada had ever decided these issues before, and I fully expect these will be the subject matter of appeal. But one of the issues was whether or not Aboriginal title can coexist with private property, and whether or not Aboriginal title can exist over submerged lands. These 2 issues have never been resolved by the Supreme Court of Canada and were left to be resolved from the Chilcotin case, which many of you will know was decided about 11 years before in 2014. The Chilcotin case, which was the first case to declare Aboriginal title in Canada, specifically exempted private property and submerged lands. Left that for another day. So this court looked at those issues and decided. We have a decision that now recognizes that Aboriginal title and fee simple interest can and do coexist, and we have a decision that has determined that Aboriginal title can and does exist over submerged lands. Now, there are many sub-issues that are of great interest to lawyers, but I don't know how much they'd be of interest today. Things like equitable defenses of bona fide purchasers for value without notice, limitations, laches. These are very interesting topics that the judge, in a very well-structured, reasoned set of her decision, goes through each of the parties' arguments on each of these issues, then goes through her analysis, applying the law, and then reaches her conclusion. So if you pick up the case, you can look at any of these topics in isolation. You don't have to read the whole almost 1,000 pages front to back. You could actually go issue to issue. I want to emphasize something that was very important, and I think I said it earlier, but I want to make sure for our discussion that I emphasize this point. This case was never about challenging the fee simple with respect to privately owned lands. The case was brought against the Crown for return of public lands that were wrongfully taken from the Cowichan. It's important for you to know that this was made clear even before the trial commenced. There was an application brought to give private property holders notice of the litigation in case they wanted to come participate. And a justice, not the judge who heard the trial, but another judge on a preliminary issue, decided because the private property holders' interests were not an issue in the litigation, because no relief was being sought against the private property holders, they were not given notice, they were not invited to participate in the litigation. The emphasis that the judge made in this case about the property interests of Richmond and Canada that she found to be invalid was based on equitable principles. And the way this might play out, I'm sure some of my co-panelists and some of the people in the audience are wondering what's going to happen in the future to private property interests now that we have a declaration of Aboriginal title that encompasses private property. The trial judge was very clear to say, in looking at the equitable principles about whether or not to grant a declaration of invalidity, about the relative importance of the land to the First Nation as opposed to Richmond and Canada, about how Richmond came into possession of its land, given that it got it as tax forfeitures and never paid value for the lands. So the judge was very conscious of looking at equitable principles and determining whether or not to make a declaration. And that becomes of significance, I think, because contrary to what you may be reading in the media or what some people are saying, it doesn't follow from this case that private property holders will be ejected or lose their property. On that point, I do want to emphasize something else. The Cowichan Nation, the people of the Cowichan Nation, have been patient and measured in their approach to restoring their homeland, to getting their territory back. They did not go after private property interests in this litigation. You'll know from reading the case and perhaps from the brief summary I just gave that they've been very patient and respectful in their approach to recovering the land that was scandalously taken from them. So for our purposes, that may give you some comfort about what's likely to come in the future. What I've tried to emphasize is that the lands in question were settlement lands, that the land was wrongfully taken from them. The lands that were held by Richmond were not purchased. The relative importance of these lands to the Cowichan Nation as a place where they met annually for decades, if not hundreds of years, was their central hub, or a very important part of their homeland and their seasonal round. And the last point I'll make about that is back at in the 1850s, when there was a colonial government in British Columbia, just before the gold rush was to occur, Governor Douglas made a promise to the Cowichan people. Settlement was coming, and Governor Douglas, who didn't have funds to enter into treaties, met with the Cowichan and said, look, if you don't get in the way of settlement, if you let the settlement of these lands happen peacefully, you will always be treated with justice and humanity. And the judge found that this promise had the hallmarks of a constitutional obligation. Now, what we know was what happened in spite of Governor Douglas's promise to the Cowichan Nation was their lands were sold out from under them, and they were made trespassers on their own lands. This is the historical framework, the background against which the judge was asked to make a declaration about who was going to be the title holder of these lands. Um, I have several passages of the reasons that I was going to read to you, but I think I may have gone on longer than I was intended to. 5 more minutes?
Yeah.
Okay, thank you. I'll read some passages to you about, and my co-panelists and I discussed this, and they said they would also be interested in me referring to the passages that might give some solace to private property holders in the claim area. So here's one. Fee simple, this is paragraph 2208. Fee simple interest in the exercise of associated rights will go unaffected in practice when Aboriginal title is recognized over the land, unless or until the Aboriginal title holder successfully takes remedial action in respect of the fee simple interests, or preferably until the matter is resolved through negotiation between the Aboriginal title holding group and the Crown. In this case, the Cowichan do not challenge the validity of the private landowner's fee simple interests. In my view, the Cowichan's Aboriginal title and the private fee simple interests will exist in the same land at the same time until future litigation or negotiation further modifies them and or clarifies the practical aspect of the relationship. This goes beyond what I am asked to do in this case. Then what the judge says at paragraph 3,516. If you're still reading it at that point. The plaintiffs submit that declaratory relief confirming the Cowichan's legal rights is warranted and necessary. The Cowichan land and fishery at the lands of Cluctinus were wrongfully taken from them, and the declarations will resolve long-standing disputes over who has the right to use and benefit from the land. They do not seek to displace private owners on the land in this action. Although recovery and restoration of their village and surrounding lands may be their ultimate objective, they accept that this may not happen all at once. They say the declarations will help set the Crown and the Cowichan on the road to reconciliation at the negotiation table and help uphold the honor of the Crown. And one more?
One more.
One more, okay. 3,551. Richmond's submission that a declaration of Aboriginal title will destroy the land title system and wreak economic havoc and harm every resident in British Columbia is not a reasoned analysis on the evidence. I'm going to pause there. Lawyers call that an argument in terrorem. It's hyperbole taken to the level of trying to cause fear, and here's what the judge says about that. It inflames and incites rather than grapples with the evidence and scope of the claim in this case. After a hard-fought trial that took over 500 days, the plaintiffs have established Aboriginal title to a small area on the Fraser River where they historically had a village and harvesting areas. Their Aboriginal title is limited to that area over which they have proven sufficient and exclusive occupation. Within that area, there are lands now owned by Canada and Richmond, and some privately owned land. The Cowichan have not made a claim for return of land from non-parties, and the property rights of the private landowners are not undermined. A precedent that will follow from this case is that provincial Crown grants of fee simple interest do not extinguish nor permanently displace Aboriginal title. And then she cites sections of the Provincial Land Title Act. So I had a bunch more, but I am taking a lot of time. I'll just conclude with this thought that I know Many people are concerned about a change in the status quo, that especially with declarations of defective and invalid titles for public title holders. But I think it's important to recognize and remedy the historic injustice that occurred in this case. And those were the equitable principles that the trial judge applied in reaching the conclusion she did. Thank you.
Thank you so much, David, for bringing us up to speed and bringing us all up to the same page and reading some portions of the decision. I think that was really important. We do have a really full room, so before we go to questions for our panelists, I just want folks to know that there are some seats up in the front. We're not that scary, so if you are looking at sitting down, those who have a seat next to you that is open, just put your hand up. So the folks in the back, if you do want to sit down, there's lots of seats. Come on down. You're more than welcome to join us and stay a while. So I do have a few questions for our panelists, and then we will open it up to the floor, as I mentioned off the start. My first question for the panelists, and we'll start with you, Robin, on this one. There has been significant media discussion about the impact of this decision on private property. And David did speak a little bit about this, but I am wondering if you can share your perspective on this.
Sure. First of all, thanks for having me here. It's an honor to be on this panel, and thanks to David for giving a very, very useful and succinct description of the judgment. He packed a lot in a very short time, and to get to 3,550 whatever is pretty impressive. I want to say that I'm going to comment primarily on the attention that the case has drawn in relation to private property owners. We're acting now for one of the private property owners in the area. I'm just not speaking for any client, I'm just speaking on my own ear. But I think it's an issue that's and is continuing to attract a lot of attention. And I appreciate particularly the reference that David made to that one paragraph about incite and inflame, and I certainly hope that's not anything I do today, but I want to comment on that statement by the judge because these are very weighty, complicated, and significant issues. And one of the best parts about being on this panel was the discussions I had previously with David and Reese, and I was like, man, it's nice to be able to talk about these really tough issues in a respectful and informed way. And I personally don't believe that raising some of the potential concerns of the decision should be considered disrespectful. I hope not to the excellent work David did at trial, to his client's victory at the trial level decision, to the interests of all parties. I do think there are legitimate issues here. I also acknowledge that the court did self-limit in some respects where the resulting findings and declarations went, or at least was limited. To me, that's not the real question. The real question is, how far did the limiting go? Particularly in circumstances where the private parties were not given notice. So in this case, as it relates to private property and Aboriginal title, the court didn't just find that there's Aboriginal title in the entire area. That's the first step in an Aboriginal title case. Then you have to turn to, is the infringement justified? And there's a test for that. It's a term of art, but there's a whole bunch of law on that. So first of all, does the title exist? Secondly, is it infringed? And thirdly, is it justified? And so I think one of the issues that exist, for any private parties impacted by this decision is, well, you don't have a declaration that says your title's ineffective and invalid. But what do these findings mean? And perhaps more importantly for this discussion, what do those findings of law mean for the larger province? And so on that point, I want to talk about two particular findings that I think is why this is getting a lot of attention. David mentioned one of them, that Aboriginal title and fee simple can coexist. And this has been a bit of a live debate for anybody who's been following the HIDA Rising Tides Agreement and the legislation of 2024. So, here's how I see it. Private land, you have the right to possess the land, to occupy it, to use it, to decide what use it's put, and to get the economic benefits from it. In Aboriginal title, you have the right to possess the land, occupy it, determine the use to which it's put and get the economic benefits from it. To my simple mind, it's very hard to see how they can both exist at the same time. But the court found that, and I'm going to comment a little bit on that. The other thing I think took a lot of attention in the media, and I think will continue to do so, is the finding that the indefeasibility provisions of the Land Title Act are not really indefeasible. So when you buy a house, you go to your lawyer, first thing your real estate agent does is put in the contract subject to satisfactory review of title. And then you go to your lawyer, and the lawyer pulls the title, and it refers to all kinds of limitations and covenants, and you pull them off, and they're usually old BC Hydro right-of-way things, and your lawyer says this is, you can live with this or you can't live with it. But it's all in there, in the registry, and it says, subject to those things on the registry, you own this, full and clear. And now what this court has found is that, no, that doesn't apply to Aboriginal title, which is a prior and superior right in the sense that it comes before that legislation. So I think those are two important findings for the province as a whole, and I think I know that they're raising very legitimate questions, no matter what the court said about we're not trying to, upend the entire apple cart here. Fair enough, but the devil's in the detail. The nuances are super important. So if you're trying to borrow money against either the private properties, that are directly subject to this or potentially elsewhere, what are the lenders thinking about this decision? We can say whatever we want about what the judge said, what the judge thinks people should think, but what are the lenders actually thinking? What about the bond analysts? Someone told me today, bond analysts are asking about this case already. You don't get to, say, oh, you're overreacting. You just don't get to. I don't know about you, but when my bank tells me what rate they're going to give me, I don't have a lot of negotiating room. And will they have different rates in different areas of BC? Will they have different rates in BC than elsewhere? Will they themselves in their internal risk assessments be considering the status of ongoing Aboriginal title claims? Maybe yes, maybe no, but these are things outside the control of anyone other than the lenders. So I think, you may say, well, that's not the biggest concern in the world in the grand scheme of things, and if that's your view, fair enough, but I do think it's a legitimate thing to raise. I also wanted to talk a little bit about the fact that the parties weren't there, the private parties weren't there. Not just they weren't there, they were ruled not, subject to being giving notice. Although the court did say you could give notice, but nobody gave them notice, formal notice. So I think there is a live question, despite all of the facts that David referred to, which I think most people would say in many respects are somewhat sympathetic as it relates to the dealings between the Crown and the Cowichan. Third parties were kind of on the outside, and all of a sudden, this happened. I want to just make one last sort of set of comments related to how big a deal is this? Why are people upset? Where did this come from? And to the extent that there are people that are worried about this decision or surprised by this decision, there's been, I think, some comments about, the judge went too far here. How did this happen? Where did this come from? I want to put this in context of a lot of other things that are happening on the larger reconciliation file that I think is important to draw together. Because, as we sit here today, talking about the Cowichan Tribes Aboriginal Title Declaration, you also have the Haida Nation recognition legislation where Aboriginal title has been accepted and agreed to. The related consent order that was endorsed by the court just, I think, a couple of weeks ago. There's ongoing negotiations throughout the province. I know at least in the Sunshine Coast area, the province has committed to negotiating Aboriginal title. So can they really both exist? How does this all fit together? Well, how certain is fee simple? How does title relate to fee simple? Really important questions. And so here's a few factors that I want to note that the judge note. This is not me bringing it up out of the blue. The judge noted that The province did not argue extinguishment of Aboriginal title in this case. There is a live issue, at least in my view, as to whether the issuance of fee simple grants can extinguish Aboriginal title. Extinguishment sounds like, not the nicest word. It is clearly a legitimate aspect of the body of law related to Aboriginal title. It's been talked about ever since, the Calder decision in 1973. There are live debates and questions about whether, in 1997 in Delgamuukw, Chief Justice Lemaire's comments about the province can't extinguish, whether that's binding, whether the court reopened that in the Chilcotin decision. I'll just say I think they're live issues, and indeed the City of Richmond brought them forward. The province chose not to. I can't say why they didn't, but I've noted publicly that the province has civil litigation directives that commit to not arguing unilateral extinguishment, and it was not argued here, and the court noted that. And whether you think that argument should succeed or not, I can only imagine that the City of Richmond is in a difficult position making that argument before the court, and the province itself, the party who's they're saying extinguished the title in the late 1800s, early 1900s, has not taken a position. So I think, it's fair to say respectfully that the province has to bear some responsibility for that decision because the court noted it. And it didn't say that's why it reached the decision, but the court noted it. The court also noted that the province had argued in this case that Aboriginal title and fee simple cannot coexist. They both give the right to the use and possession of the land. But the trial ended in 2023, and then the judge goes to write the decision. In 2024, the government reaches an agreement with the Haida Nation recognizing Aboriginal title and fee simple over the same land. The opposite position of what was taken in the court, at least according to the court. Now, the Haida deal does have provisions that purport to protect private property interests. We can talk about that more another day. But the judge noted this. I don't know if I don't think it was brought up again in a subsequent hearing. Maybe the judge saw it on the news and looked at the statute book, but it was brought to her attention, okay. And she said, I note that what I'm finding here is consistent with what's been done in the Haida Nation Recognition Act. Again, not saying that's why, but noted. And then even on the Land Title Act decision, the Land Title Act is not indefeasible title as it relates to Aboriginal claimants. The court noted this provision that I'm sure none of you have ever heard about or cared to talk about before. A couple of years ago, the province put a provision in the Interpretation Act. I think this is under the DRIPA mandate, Declaration on the Rights of Indigenous Peoples Act, that says effectively provincial statutes have to be interpreted in a manner consistent with the United Nations Declaration on the Rights of Indigenous Peoples. And I think there's a lot of complications that potentially come from that. There are very different views on it. We can, again, talk about that separately. But what I think is important is that the court relied on that. Well, the court is taking cues and directions from the legislature and the government on some of these things. And I think all of this, at minimum, is increasing the public confusion at best, sensitivity, concern at worst about where is this all going and how does it fit together. And can they both coexist or can they not? And I'm going to talk a little bit more about the coexistence when we turn to local government specifically, but I just wanted to offer those comments for now. Thank you.
Thanks for those initial reflections, Robin, and I'll pass it over to you, Reese, if you have any thoughts on this first question.
Yeah, thank you, Jenna. It's pretty clear from the comments of my friends here, and I do consider them my friends, that they know a lot about the history and the details of the First Nations portfolio in British Columbia, and I know many of you in the room who I've been in sessions with in the past where we spent some time together. I say the same thing to all of you all the time. I'm a local government lawyer that does First Nations law. It's clear we've got First Nations lawyers here. I'm not a First Nations lawyer. I'm a local government lawyer. And so I want to bring this down to ground a little bit, like lots of big principles, lots of lofty case law, lots of lofty concepts have been talked about. And when I saw this question, what occurred to me as a local government lawyer is, again, bring it down to ground. The question was, can you provide your perspective on impacts on private property? And so I'll start with the City of Richmond. So I'm not counsel for the City of Richmond in these matters, so I'm speaking without being involved in anything at the trial. So right down to ground. David mentioned that a number of City of Richmond fee simple folios were declared invalid and defective by the court. I think there were actually 2. Those two folios, what they provide in reality is diking and drainage works for the City of Richmond. They're dikes and they're drainage works that are part of the flood protection works for the City of Richmond. Court found them to be defective and invalid for the reasons that David, I think, quite fairly set out, that they were obtained through tax sale back in 19-teens, I believe, or the 1920s. But from my perspective, implications for local government, these are the real implications for local government with respect to a court finding defective and invalid fee simple lands owned by a municipality. On those lands, we are almost always doing something with them. They're not, and I'll criticize the court a little bit here, she said the lands were vacant and unused. That is not what a dike is. Most people in this room are aware of that. Our lands that we own are used for things, always used for things, whether it's a city hall or a dike that provides flood protection works. So just at that very basic level on implications for local government, you need to ask the question, what now happens to the flood protection works for the City of Richmond? What happens to them? Who owns the dike? Who maintains the dike? Who's responsible for the legal liability if the dike breaks? All those questions now become, it seems to me, open and up for discussion between the new owner of that fee simple or of that Aboriginal title interest, the Cowichan Tribes, and the City of Richmond. And they'll have to talk about that. There will be discussion. There will be some sort of agreement, I assume, as to continuing the diking and drainage works for the City of Richmond. You can't have a hole in your dike, obviously. So that's just the first comment on implications. The second comment I have is more around, I think it's sort of taking off on some of the comments that Robin made, because David very fairly and accurately described what Cowichan Tribes sought in this case in relation to the third-party fee simple interest. They did not seek to invalidate those titles, 100%. We need to be really clear about that. But they did seek an Aboriginal title declaration over those lands. And when you have an unregistered property interest in the nature of what Aboriginal title is, which Robin, I think, fairly described a minute ago, it's very similar in use and occupancy to what a fee simple title provides. I find it hard to understand how there won't be some uncertainties with respect to those third-party fee simple lands, again, from a local government perspective. And I'll get into it on the next question that Jenna is going to ask us in a bit more detail, but I'll just sort of tease that issue out with this. We operate always from a place of who's the owner, who's the applicant. The first thing we ask in anything that comes before us is, who are you? Do you have the right to make this application? And our legislation says to us without any question, the person we look for is the registered owner in the land title office. So imagine now when an applicant comes forward for a development permit, a rezoning, an OCP amendment, a building permit, whatever it is, and those lands now have also an Aboriginal title declaration over them. Who do we accept that application from? Who's the registered owner? Who's entitled to the interest in those applications? It's a question, the title for this and a lot of thought I've been giving to it is implications for local government. We're going to have a little bit trickier time discerning the answer to that question when it comes to fee simple lands still held in the land title office by individuals, but now also having an Aboriginal title declaration over them. Who's entitled to make the application? Who's entitled to oppose the application? Who do we issue the permit to? Who runs the whole process? These are some of the questions that are occurring to me. Make it really clear today. There's a lot of questions, and I'm going to candidly admit I don't know the answers. So don't ask me for answers on these questions today, I guess is what I'm saying. I joked with my friends when we were chatting that I'm smart enough to ask the question, but I am not smart enough to give the answer. So I think I'll leave it there, Jenna, and pass it over.
Thanks, Reese. David, I'm going to pass it to you and see if you have any further reflections on the media attention here on the impact of the decision on private property specifically, and hearing from your colleagues on the panel.
Thank you, Jenna. Does this work? Yeah. Both Robin and Reese are very good at highlighting some of the issues that will arise and are unanswered, and they've done a good job in pointing them out, but I think there are some answers for some of them, and for those where there are no answers, we should look at what the judge actually said, and I'll give you some examples. Reese asks a lot of good questions about what's going to happen to the dike and what about indefeasibility and registration of title. And if you look at what the judge said in the declarations, the first thing you'll notice is the declarations of invalidity with respect to Richmond and Canada's land in the title area is suspended for 18 months so the parties can meet and work out these kinds of issues. And that's a very unusual thing for a judge to do, to suspend a declaration for 18 months. It's almost only suspended in constitutional cases where there's going to be significant fallout and implications that have to be worked out. So I think that Reese is really identifying a lot of important things that have to be worked out, some between Richmond and the Cowichan Nation, and hopefully the parties will get to work and try and work these things out carefully. The question of indefeasibility and whether or not Aboriginal title and fee simple can coexist. Yes, this has been a question that's been before the courts for decades and has not yet been definitively answered by the Supreme Court of Canada and is answered in this case. But I go back to the bigger picture of what is reconciliation really about. And those of you who are lawyers or are familiar with the legal definition of reconciliation will know that it's about pre-existing Aboriginal societies who, when Britain asserted sovereignty, brought to it its claim in the face of pre-existing ongoing legal tenures. And reconciliation is about how do we reconcile the fact that those pre-existing societies continue to exist and have those laws and tenures and rights, yet British Columbia now and Canada assert sovereignty. That's what the work we're doing. We're trying to reconcile that. And I think it must be very clearly stated that the law on extinguishment is crystal clear. The province has never had jurisdiction to extinguish Aboriginal rights or title. Until 1982, it was only the federal crown that had that jurisdiction and had to do it clearly and plainly if it was going to do it. And since 1982, it's a constitutional right that cannot be extinguished by the crown. So anyway, I'm going into too much detail here. I do want to make one more point about indefeasibility, but I see there's questions coming.
David, I can't believe it with 3,728 paragraphs, 3 lawyers aren't going to agree on everything. Hard to believe.
But respectful debate at the panelist table. Thank you very much.
We're trying. We're trying.
I will note that I still have 2 more questions for our panelists, so I appreciate that you're already lining up. That's great. You might be standing there for a while, just a heads up. So as we all know, we're at the Union of BC Municipalities. This room is full of our local government audience today, the best order of government. So I want to make sure you spend some time discussing the potential impacts on our municipalities and regional districts. And Reese, I'm going to start with you in giving some thought on the types of things that local governments should be thinking about as a result of this decision. You touched on a few of them already, but yeah, quelling some of the concerns and the fear and the things that we should be thinking about with this decision looming out there. Yeah,
thanks, Jenna, and I'll try not to wax poetic on this too long, everybody, but I'll be curious when we get to the question period as to whether you share some of these concerns or questions that I do. And I've had some really, really good dialogue with David, particularly in advance. We had a good discussion earlier, and what's sort of I've realized as I've been trying to tease out how am I feeling about this decision from the local government perspective again, is that what it's feeling like to me is that it's a reshuffling of jurisdiction. That's what this is at the bottom line for us as the third level of government. It's a reshuffling of the jurisdiction between First Nations and local government. We're not a constitutional entity. Canada, the province, First Nations are. We're not. And so there's this reshuffling that I think this case is demanding that we start to talk about and understand as it continues to work its way through the courts. And we'll come to this in the third question. We've got to remember, this case is not done yet. This is level 1 of likely 3, at least 2, level 1. So we'll see where this goes. But from our perspective, I've been trying to drop things into buckets and what are implications and things we need to start thinking about if the law stays the way it is right now. What are some of the things we want to talk about? So bucket 1, I'm going to call, and I forecasted it a second ago, is who's the local government deal with? Who's the owner? And as we know, there are many things that we do every day that requires us to know that answer and know that the question to that answer. And we always rely on our statute to guide us, and the statute always says that we rely on the registered owner in the Land Title Office of British Columbia. And so this is going to be an issue, and it's going to be a struggle for us in circumstances where we have dual, particularly coexisting title, to know who to deal with and to know who has the rights to deal with us. So I just forecast that as an interesting question. And it's got, as we know in the room here, many different facets where it could arise. The second issue that I think we have to spend a bit of time talking about is taxation and revenue concerns. Let me back up. Local government is a taxing authority. We know that. And I think when we're dealing now with Aboriginal title lands, those that certainly have been invalidated and defective, where they're just Aboriginal, I shouldn't say just, where they are solely Aboriginal title land. But we can look at it in the same way where there's the coexisting nature. I think we have to ask the question openly now, who is the taxing authority? Is the local government still the taxing authority when it comes to Aboriginal title lands, or is it not? Is the First Nation a taxing authority with respect to fee simple owners that are on their Aboriginal title land? These are open questions that, again, I'm not smart enough to answer right here and now, but I pose the question because it's a real question as a result of this decision. A big shifting of jurisdiction is what we're being asked to consider here. I'm going to give an example to bring it back to ground, though, again, of a almost immediate implication from this case with respect to the revenue of the City of Richmond. And so it'll draw out a real example of how this case impacts local governments. And this will be repeated in other places if we have more findings like this. The other lands that were declared invalid beyond Richmond's were lands that were belonging to Canada and the Vancouver Fraser Port Authority. Of course, those are federal lands, and those lands, as we all know, are not taxable in our world. We don't tax federal land. But we do have a regime that's been set up by the federal government called the Payments in Lieu of Property Taxes, the PILT Act, for those who know about it. I know lots of you do. I do lots of PILT work. And what this result will lead to, subject, of course, to David is bang on in what he said, that there's an 18-month window here for people to talk. He's bang on with that. It's about 16 and a half months now, not 18 anymore. Time flies. Time goes quickly. But the Vancouver Fraser Port Authority lands in Richmond have been declared invalid and defective, right? Those lands, it seems to me, are not piltable anymore. So the City of Richmond may, I'll stress may, I don't want to draw conclusions here, it's an implications discussion, may lose a source of revenue from those federal lands that had paid in the past annually, as we all know, PILT revenue to them as part of their budgetary process. So that is a real implication of this judgment that needs to be sorted out between the parties. Richmond will lose annually PILT payments for those lands that have been declared invalid and defective that were owned in the past by the Vancouver Fraser Port Authority. So that's a real bring it to ground example of the sorts of things that we need to start thinking about and dialoguing about with respect to this matter. So that's bucket number 2. I have 2 more. I'll be quick, I promise, to my friends.
You had 3 when we spoke. You got 4 now?
I added another one since I chatted with Robin. The third bucket that's worth mentioning is regulatory bylaws and approvals, and I think I can be really quick on this. Aboriginal title lands, technically lands that are federal in nature, 9124 of the Constitution Act, Section 35 of the Constitution Act, 35.1, more specifically the Constitution Act, you know, those lands are always seen as lands that are more federal in nature and away from the jurisdiction of local government day to day. So what happens to our regulatory bylaws with respect to the lands that are Aboriginal title and are coexisting Aboriginal title with fee simple? It's, again, a legitimate question to start asking ourselves. Do our OCP still apply? Do our zoning bylaws apply? How do our development permit guidelines apply? We have to ask those questions, and I think regulatory approvals outside of bylaws are also similar things we have to start asking ourselves about. How do we issue building permits for significant development on lands that are coexisting between a fee simple owner and an Aboriginal owner, right? Very complicated jurisdictional question to answer. And the last bucket, I promise, I might think of a fifth, Robin, before I'm finished talking. I think of things fast sometimes, is service provisions. Local governments, what do we do better than provide services? We're wonderful at it, and we provide tons of services every day to fee simple owners and other folks, even federal and Crown agencies within our communities, police, fire, parks, flood protection, garbage, recycling, you name it, we provide it. We try our best to provide these services. How do those services now roll out and are provided on Aboriginal title lands? I think, to be fair, not to be, and we'll come to this in question 3, we should not work in this discussion from a place of fear, ever. I will say that multiple times today. We do not and should not work from a place of fear. Work from a place of reality, be respectful, not from fear. And so I don't want this to come across as a comment that, to David's comments about what was said in the litigation about creating fear and panic. That's not the point of this. But there is a legitimate question to ask around how are services now to be provided by a municipality to lands that may not necessarily be within our direct jurisdiction anymore. Who pays for them? Let's be honest. Who pays for those services? Taxpayers pay for them. If we're not receiving taxes, how do we provide them? There's probably simple solutions. Service agreements might be one of them. There might be other solutions that more creative people can think of. But these are the on-ground, early discussion points and implications that all of us need to start thinking about in the event that this litigation stays in the same place that it does. Because it won't be the last Aboriginal title claim in BC, folks. There will be more. There will be more over fee simple properties, and maybe David and Robin can address that in a more detailed way than I can, but there will be more. And so these are some of the concerns. These are some of the issues that I think we need to talk about, and love to hear from my friends as well on this point. Thanks, Jenna.
Thanks, Reese. Robin, I'll go to you if you have any thoughts on this particular topic around things that local governments should be thinking about as a result of this decision.
Yeah, I'll just add a few points to what Reese said, but I'm going to start with this. By definition, reconciliation requires the changing of the status quo. And I think it's important that not every time there's a change that doesn't work to one's, personal or particular advantage, that you say the sky is falling, oh my God. I think it's very important to acknowledge that. I also think it's important to acknowledge that when you don't solve things through negotiation and end up in litigation, a court by definition has to give directions at a point in time, one-shot deal. So, for many reasons, court is generally the last resort. But I'm going to put a caveat to that. That also doesn't mean that there's not a potential concern about the breadth and scope of the consequences, even allowing for those 2 points. There still can be a potential concern. And I think there are live and important issues, and I'm not looking to say the sky is not falling, and much of this will be sorted out in a practical way. I used to be, for a period of time, a provincial treaty negotiator, and we would deal with a lot of these things, and you can see how this is addressed. It does amount to a shuffling of the deck, of the power, but in the treaty context, it's structured, it's orderly, you know exactly who's doing what, when, and where. There's a chapter on service provision, on jurisdiction, on building codes, on all these things. And to the extent there's another statute out there that somehow gets tied in and complicated, there's a provision in there, section 12.2, as it relates to the NISCA agreement, whatever, right? We don't have that yet, and we will, I think some of that will indeed get sorted out. My concern is not that that won't happen. My concern is that the delta is pretty big. And I don't want to get too technical here, but I think the application of provincial laws on Aboriginal title lands is a very important question for local governments. And in 2014, in the Chilcotin decision, the Supreme Court of Canada said, well, here's how it works. First of all, you look at the act and read it and think, did the legislature really intend it to apply to Aboriginal title, as if they were ever thinking that when they drafted these acts, especially years ago. Come on. And then you have to decide, if so, does it infringe? And if it infringes, is it justified? And this is a messy, complicated question. And in that case, it was principally the Forest Act. So there's been 3 Aboriginal title findings in British Columbia, Chilcotin, New Chatlet, and here. And in New Chatlet, if you look at the order, it says, you know, all these other acts are going to apply for the next 2 years. You don't have to fight about or argue about this question while we try and, you know, get somewhere. That's not here. So does the right to own, use, possess, and in Chilcotin, the court added manage Aboriginal title lands, does that mean that First Nations that hold title have the right to co-zone? The provisions that say, you know, the Aboriginal titles holders' ability to exercise it will be limited by the rights of the fee simple holder. I forget the exact quote, but David mentioned it. Well, fee simple holders you have your fee simple, but you have all kinds of zoning bylaws and, you know, requirements for permits, et cetera. So will First Nations be able to do that? It's important to remember that in this case, the declarations of Aboriginal title relate to a very important and significant area, but just that part of the province. But for my part, I also wonder what's going to happen if and when Indigenous groups elsewhere say, we don't have however many millions of dollars this costs and 500 days and you know, all these years, and will you please just respect and recognize our Aboriginal title and work with us without having to fight that out? And that'll be a hard question if and when you get that as local government officials. I mean, if you say yes, then you're within the questions that I raised, and if you say no, it'll be a very, you know, won't be well received. So these are important issues.
Thanks for those thoughts. David, any reflections on this question around local government considerations?
I'll be very brief because I know very little about local government. I was very interested in Reese's comments on reshuffling jurisdiction, because there are 2 scholars, legal scholars, named Kent McNeil and Brian Slattery, who have both written on Aboriginal rights and title and levels of government. And one of their theories is that instead of comparing Aboriginal title to fee simple, we should be comparing Aboriginal title to jurisdiction, provincial and federal jurisdictions. And it is a very interesting way to look at it, and it goes to answer a lot of the questions about taxation, revenue. Anyway, that's just my observation on reshuffling jurisdictions. The only other point I would talk about is the breadth and scope of consequences and unnecessary fears about the sky is falling. In 1984, our highest court in British Columbia ruled that Aboriginal title could support an injunction against industrial logging on Mears Island. And the court did that in the face of arguments from the logging industry and Macmillan Bloedel that the sky is going to fall, nobody will invest in British Columbia. If you invalidate licenses that have been issued lawfully on the basis of an Aboriginal title claim, there'll be a rash of injunctions brought by First Nations. It'll be the end of British Columbia as we know it. Well, there were virtually no, the Court of Appeal went ahead and granted the injunction, stopped the logging on Mears Island, and those ancient cedar trees are still standing today. But the important point is there was no rash of applications based on that. There were no rash of injunctions that came. The sky didn't fall, investment didn't cease. And those kinds of arguments, when they're made, I don't think they serve anyone. I think we have to focus on the actual facts in any individual case.
Thanks for those thoughts, David, and it leads us well into our last question for the panelists here today. To Reese's point, this is level 1 of at least 2, likely 3 levels of legal challenge, and it is, as David pointed out, there's lots of language that we can find in the decision, but it also does raise some uncertainty. And so I am curious to hear your thoughts on what options you see to help create some certainty, or at least to calm some of the concerns that some people hold while the appeal process is going through. And David, I'll start with you, just based on the comments you just made.
Great, thanks, Jenna. I think a lot of what I've said today already goes to that, but I think I'll just put it in perspective in the actual appeal process in this case. The amount of time between the trial decision in Chilcotin, the trial ended in 2007 after 5 years. That one was only 339 days of trial. From the end of the trial in 2007 until the Supreme Court of Canada made its final decision declaring Aboriginal title unanimously for the first time, that was 7 years. And I think that if one were to make a guess about how long it's going to take for the appeal process to work its way through in this case, it'll probably take at least that long because there's more parties and a larger record. But I think in the interim, I am interested in the fact that British Columbia publicly announced that they were going to seek a stay of the court orders, the declarations, and they haven't brought one. But I think it's because people are coming to realize that this isn't the end of the world, that this is a very measured decision. The 1,000 pages, I haven't heard anybody say it's wrong. I haven't heard anyone say the reasoning is faulty. I haven't heard anyone say the judge didn't make meticulous findings of fact. So what I'm saying is I think people, knowing the history of the Cowichan Nation, knowing what their background here for the last 150 years, how they've been patient and respectful, how they haven't gone after private property interests. I think what we can take from that is that there will be time to breathe. There's 18 months from the date of the decision for Richmond and Canada to meet with the Cowichan Nation and work out what's going to happen to that land that's where their title's been declared defective and invalid. And British Columbia has been ordered by the court to meet with the Cowichan Nation and negotiate in good faith. It's to uphold the honor of the Crown with respect to the fee simple interest in the claim area. Now, I think we can breathe and take it for granted that nothing horrible is going to happen in the short term, and the 7 or 8 years or whatever it takes for the appeal process to work its way through will be met with reasoned, patient understanding while that goes on.
Thank you, David. I'll go to you, Robin.
I think I've covered a lot of it. I mean, I really want to focus on not the sky is falling, but that there are, I think, some legitimate issues. That there are things in the judgment that I disagree with. There are all the appeals filed, but I think, I don't think people should panic. I've said that publicly, and there is a process for all this. But I also don't think it's just going to be smooth sailing. And when I hear things about the bond analysts and lenders and things like that, we just can't wish those away. Maybe you're not concerned about it as much as some others would be, but it's going to be an issue. How do you manage the certainty? Well, first and foremost, I think an open and respectful dialogue has to happen. If we don't have that, we're really in trouble, even in a best case scenario. So I hope we're contributing to that today, but it has to continue. It has to continue. These are, at minimum, very complicated, important issues. No, I don't think anybody would dispute that. I think that it's also important to recognize that when the court directs the parties to negotiate, at least in part they're negotiating in relation to the interests of other parties that affect the interests of other parties. And the governments and the Cowichan may be able to negotiate certain aspects and issues flowing from the decision, but nobody can negotiate the decision itself. You can't change anything. You say, well, I think the court's wrong on this. I agree. I'll give you that and take that. It doesn't work that way. Government couldn't pass a law to do that if it tried. This is constitutional. So I think that we have to have a measured discussion. We have to find as many practical ways to mitigate and minimize the risk, but we shouldn't also take false comfort. I think it's having real implications already. In terms of the appeal process, David's more involved in that than I am, but You know, I think this case raises very, very important questions. At minimum, I'm sure that's going to happen. And I don't know if there's better ways to do it. You'll hear people talking about a reference case that's super complicated in some ways because it doesn't, you would never send all the questions to a court, and it would put the Supreme Court of Canada ahead of the Court of Appeal. I don't know. There are things that need to be thought about. Where I respectfully probably differ a little bit with David is I don't disagree that the Cowichan tribes were very careful and deliberate in not seeking certain things. I fully accept and respect that, but I do think there are these potential implications, and I just don't have an easy answer for how we're going to sort this all out in the near term. I just think there's too many open questions.
Thank you for that. And Reese, I'll go to you.
Thanks, Jenna, and David and Robin, thank you for those comments. I'll try to be brief again. I've got 3 points, not 4 or 5 this time, but 3. The first and foremost, and I've said this already, but I think it's worth repeating, is that I really, really hope that all of us can not operate from a place of fear as we continue this dialogue. I don't ever think that looks good on anybody. I don't care who it is. If you operate from that mindset, it's bad news from the beginning. So like we are talking today, respectfully, directly, disagreeing, but being very respectful about it and listening to each other's views and thoughts on this, respectful dialogue is a must in this situation. So that's not legal at all, and who the heck am I to say that, but I'm going to say it because I'm just as entitled to say it as anybody else. Don't work from a place of fear. But on the flip side of that, and I hope this doesn't sound contradictory, it may slightly, but lawyers are good at contradicting themselves. I've learned that over the years. I'm not going to light my hair on fire with respect to this judgment. I'm just not. I'm not going to light my hair on fire. I know lots of you in the room have heard me say that already. I'm repeating myself, but it's becoming a bit of a mantra for me. I will not light my hair on fire, but I'm also not going to undervalue and underestimate the implications and consequences of this case. One thing all 3 of us will agree on, there will be no distinction between us. This is a massive case. It is really important. No one on this stage will disagree with that. It is a huge case. I've said publicly, I think it's the most important case in the history of the province. I've said it publicly and I say it here. So we cannot pretend that it's not important, because it is. That's number 2. Number 3, actually I think that was still part 1B of number 1. See? Pretty good, right? Pretty good. Point number 2, though, is to pick up on a theme of David's, and I would really like to support David in this. He's said it multiple times. The Crown has put a stay in place on this, or more or less a judicial stay for 18 months. Not a lot of time, but it's also a clear indication by this court that she expects, particularly the Crowns, and I will focus my comments particularly on the province of British Columbia, to get moving, to start doing something. More than they're doing. I don't mean they're not doing anything. That would sound disingenuous. To do more, to start getting this moving and starting to work on some solutions to some of these things. Particularly, I would suggest in relation to the third parties whose titles have been affected. There needs to be a resolution for those people. They do not deserve to have uncertainty with respect to their title moving forward. So get on with it. That's the second point. Take advantage of the 18 months, right? Take advantage of it. And the third point, and again, I think all of us on the stage will agree to this, is that, and Jenna said it in sort of what I've said, is that please recognize this is the first step of very likely 3 steps in the process. David and his colleagues and the other 80 lawyers or so that were on that 513-day trial must be, losing sleep at night thinking we've got to do this not all over again, but in another fashion in the Court of Appeal and very likely in Ottawa before the Supreme Court of Canada. So this is not going away anytime soon, and we don't know ultimately what the court is going to do with this. The law that we're talking about today may not be the law after the Court of Appeal deals with it, and it may not be the law after the Supreme Court of Canada deals with it. Very simply, what I want to encourage people, and it loops back to my first comment on don't work from a place of fear. Trust the rule of law and trust our judiciary. We owe them that in this case. We owe the trust to the system, and we've got to be, I think, true to that at this point. This case is too important to start running around and lighting our hair on fire, right? Trust the system, trust the judiciary, and trust the rule of law. And let's hope at the end of the day that the rule of law finds a balance here that takes into account all British Columbians and frankly all Canadians, because this isn't just about BC, this case, it's about Canada. So let's hope that our legal system can find that balance and all of us will be treated well at the end. So those are my thoughts, Jenna.
Amazing. Thank you all for your reflections on those 3 questions. I want to recognize that I have a panel of 3 lawyers, and I'm running 15 minutes ahead of my scheduled remarks. So that means more time for questions, folks. Nice work to these guys.
Do you want me to bring up points 4 and 5?
No, we're going to go to the floor. This gentleman has been standing for a long time. So sorry, I have one more order of business here. So now we do have time for questions. When you approach the mic, please state your name and the name of your community. I will ask that delegates respect UBCM's conference rules and procedures, which stipulate that only those that are elected officials from local governments and member First Nations have the privilege of the floor. We'll go to the back mic first. Thank you.
My name is Colin O'Leary, known troublemaker here at UBCM, I think, for standing at mics when I shouldn't. And yes, nice to have 2 passed.
Your community, please.
Nisconluth Indian Band, and I have something very practical I do want to ask as a quick question, which is that when I think about this duality of Aboriginal title and freehold, fee simple title, it makes me think of specific land claims, which happen all the time and have existed for quite a while. And I looked at that as maybe a practical solution when you look at this actually playing out. I'm curious the panel's thoughts on this, where many specific land claims include privately owned land and municipalities even. And the solution is not the eviction of these people or the cancellation of their fee simple title or anything like that. It's instead compensation and alternative lands that are supplied. It won't work in all the situations, I appreciate that, if it's really kind of core territory or a very specific sacred spot, let's say. But I'm really curious the panel's thoughts on maybe that being kind of an example of how this could practically play out in the future. And so I'll leave it at that.
Thank you. Who wants to take that one first? We're going to go to David.
David, do you want to take that?
Sure,
Yeah.
I'm happy to. If you're talking about specific claims and the specific claims tribunal, it has a very limited jurisdiction. It can't make decisions about Aboriginal rights and title, and it has a monetary limit to what it can award. But it was specifically set up to overcome the issue of limitations. So I guess what I would say is, in your question, there's a lot of practical advice. And if I could aim that advice at the province to listen carefully when they approach First Nations to negotiate, that would be where I would direct it. Now, I'm not at liberty to speak today about negotiations. My hands are tied a bit because of the system and the appeals. But I did write an article that's published in The Advocate about 10 years ago on mapping Aboriginal title in British Columbia. The Advocate's a legal periodical. And what it proposes is basically a kind of royal commission that includes First Nations and oral historians, but that the body would have the responsibility of, if you like, making a map of which First Nations had claims where and where there were overlaps. And it might significantly advance the process, but those are my comments.
Thanks for that. Anybody want to add anything to that?
I'll just add a brief comment. I mean, I appreciate the sort of lateral creative thinking, and wherever there's an opportunity to look at some models and, you know, benefit from, that would be great. But I do just want to flag that it is a little more complicated here, because it's not just, there's much more to this decision than a promise was breached about the preservation and transfer of some land. If it was just that, it would be very similar to the specific claims, you know, and some of the other cases about wrongful dealings with reserve lands. But this has overlaid on it the Aboriginal title component, and so it makes it more complicated. Would a declaration of Aboriginal title remain, and how could it not? You know, following negotiations, the specifics claims process, as I understand it, specifically says private land isn't on the table unless it's, you know, brought in through a willing buyer, willing seller, and you know, I mean, I suppose that principle applies anywhere at any time, but David mentions he's not at liberty to speak to certain things, and I fully respect that. And I don't have to so self-limit because the folk I represent aren't in negotiations, don't even know what's going on. So it's a complicated issue. How's that for a lousy answer?
There's more chances to answer other questions, so we'll go to the front mic, please. Yeah.
Cowichan Valley Regional District. I'm going to talk about ground level here that you were talking about, and ask yourself to put yourself in my position. I don't have the kind of background, the kind of intellect. I'm sorry, I don't. And everybody here is ground level. What would you say to the resident that comes to you or me on ground level, Mike Wilson, and says, I'm scared, what's going on? If I try and tell them everything or even part of what you've said here, I know what will happen. Oh, you're just talking like a politician again. What do I say to them apart from, don't worry, because that's not an answer.
Reese, go ahead.
Well,
How many answers you got for this one?
yeah. I'm struggling for one, actually, so.
Could start with the fact, I am a politician.
Yeah. I honestly don't know what you should say to people. I can't give you the right words at the right time, sir, but I'm going to kind of go back to, and again, those folks in the room that know me have heard me say this many, many, many times, and I hope it's coming through today in the comments that I've already made. I don't think we should be candy coating this circumstance. I think we should be straight up with people on how important this case is. And if you want to adopt my sort of statement around it, it looks like what we're in for is a jurisdictional shuffle, because I think that's what it is. I really do. I think my friends agree with that sort of characterization of this, that it's the beginning of a jurisdictional shuffle. But where it's going to end, I don't know. So I think we have to be honest with people. I think people need to be told that there's systems, people, and a lot of smart people in place that are going to deal with this, but that the outcome is uncertain, and that there's very likely to be some jurisdictional change in the province of British Columbia as a result of this decision. And exactly where that's going to land, I don't think anybody up here or in this room can predict at this point. So that's, I guess what I'm saying is tell people the truth. Tell them the truth.
Yeah, and that's going to help, obviously. It's going to help a lot, because I need to know how to interpret everything that's going on here.
Yeah.
It's very, very complicated. Thank you for that.
It's complicated, if I may.
Of course, go
I
ahead.
mean, people have to put it in perspective. That's not underestimating or understating the importance here. I mean, I remember I was a young lawyer I would come to the Victoria courthouse many years ago for some probably small file that I ended up losing, and I would see a whole bunch of people, in gowns arguing that, oh, that's the Honey-Mateen case, oh, that's the Honey-Mateen case. And everybody talked about it like it was the most important thing that had ever happened in the legal universe, because what if the court finds Aboriginal title? And I said at the time, they're going to find title, and you're going to have to manage with title. We can talk lots about where you find title and how you deal with infringement and where did private property fit in, but I mean, good grief, they're going to find title, and they've done it 3 times now. It's going to keep happening. The system is built to deal with these things. There's appeals. Most of this decision has no direct impact in any time soon on anybody other than the parties in that area. That's not to say it's not important. It's not to say it doesn't raise serious questions, but people have to put it in perspective and recognize that these things, they go through the HIDA case, duty to consult. Oh my God, everyone has to consult on every single decision. How is that ever going to happen? Well, there's lots of problems with how that's implemented, but it's not been the end of the world, So I would say that, just put that in perspective, and that's what the legal system is for. And who knows what this is going to look like? Take a look at Delgamuukw. Take a look at the 3 decisions in Delgamuukw and how different it was from the beginning to the end. It may not happen here, but nobody knows until it's done. So until somebody has a direct impact, and I appreciate you that you're saying, what do I say to them? But that's what I would say.
Okay, thank you.
And David, you are not a politician, but you maybe have had to answer this question more directly. Do you have any insights for our folks here today?
About what to say at the ground level to people who ask, what about the implications of this decision?
Yes.
I think Reese and Robin have answered very well that saying really it only has direct application on the ground to a small area, and there's probably several years till we have the final word, but in the meantime, nothing's likely to happen in your regional district.
Good, thank you very much.
Okay.
Thank you. We'll go to the back mic.
Yes, my name's Mike Winstanley. I work for Splat Team. It's an Indian Act band based out of Enderby. And so a couple of comments before a question. I didn't bring any buckets, Reese, but I did bring my briefcase, so bear with me. First of all, I believe you may have misspoke yourself when you referred to the Aboriginal title lands as being federal lands. I think that's incorrect, and maybe the other panelists can correct me on that. Those lands are, I think the genesis of them is the Aboriginal rights that are guaranteed by Section 35 of the Constitution, which means that only the First Nation has jurisdiction over them. It's not federal lands that 9124 would apply to. It's not provincial lands that that the province has jurisdiction over. It's their own land, and we're talking about Aboriginal title, which means, and I think it was said at the panel here numerous times, ownership. That's it, ownership. Now I think we're conflating ownership with jurisdiction and the ability to pass laws. That's a whole separate question. And I know Treaty 9 right now is launching a lawsuit against Canada and the province of Ontario, saying that even though we gave up our lands under Treaty 9, we never gave up jurisdiction over our lands. We can pass laws based on Section 35(1) because our treaty rights never extinguished our ability to self-govern and have ownership and control over our resources. Cowichan haven't done that. All they've said was, this is our land, we want it protected, we want it back. So if you can, my question is, am I correct in that? In making that statement, or those statements rather?
Let me say one thing first. I mean, in regard to your suggestion that, or not your suggestion, but your statement that I said that Aboriginal lands are federal lands, you're absolutely right in what you're saying. If I misspoke, I apologize. What I meant by that, and again, it's my local government lens, local governments don't have jurisdiction over lands that are controlled by the federal government through the Constitution or the division of powers. That's my point, is that we have very limited ability, next to none, frankly, to do that. So if I misspoke, I apologize. And I'm going to put my friend David on the hot seat to answer your question.
I'm not going to comment on the specific case about Treaty 9 and self-government. I won't go there, but I did mention earlier that there were two legal scholars who have compared Aboriginal title to jurisdiction as opposed to fee simple, but Aboriginal title lands are lands upon which the claimant or the title holder can use and occupy, reap the economic benefits from the land, and the only real limits are the inherent limit. You have to preserve that land for the use of future generations, and the land can only be surrendered to the Crown. That goes right back to the Royal Proclamation of 1763, and we could get into all that, but you're quite correct that lawyers who grew up, who are my age, learned in law school that there were only two jurisdictions. There's federal and provincial, and that idea is gone. Section 35 has upended that, and in the Chilcotin case in the Supreme Court of Canada, there's quite a discussion about interjurisdictional immunity, which was based on the idea that everything had to be either provincial or federal. And what the Supreme Court of Canada has basically said is for Section 35, we're now going to have a test for justifying infringements that's going to apply both to federal and provincial, and it's no longer about who has jurisdiction. I don't know if that answers your question, but
I want to just add one thing because I'm really interested in your comments around ownership jurisdiction. And I think actually what I'm saying, and I might not be articulating it very well, and this whole shuffle the deck of jurisdiction idea, in all honesty, only occurred to me yesterday to describe it that way, because I've been struggling, right? I've been struggling. How local governments, how are they affected by this? What happens with, just drawing you really simple examples, what happens when we get a building permit application? That's what I'm thinking in my head. I'm a local government lawyer. What am I going to say to the city when they call me? And it just dawned on me. What we're talking about here is jurisdictional realignment. And so another way to put that would be, with the ownership interest that First Nations have through Aboriginal title, what jurisdictions are they going to exert themselves? What do they believe that they can exert through that ownership interest? Does it include taxing authority? Does it include the ability to limit development? Those are the sorts of questions that I'm struggling with in my mind. And I've chatted with a couple colleagues who are First Nations council, and they don't know the answer either. We're all struggling with it, right? So I think we might be saying similar things, but I understand what you're saying, that I think you're a bit upstream of me, I'm a bit downstream of you. You're coming from it, where the ownership is, and I'm looking at it, yeah, there's ownership established. So what are the jurisdictions now that will have to be realigned between the nation, who has the ownership interest, and the local government that's got this statutory, regulatory, and other jurisdictions been granted to them by the province, which of course, as we know, can be taken away tomorrow, because we're just statutory creatures, right? We're not constitutional creatures. So I don't know if that helps or not.
A little bit, yeah. I think it also raises the issue of, because you only have statutory authority, and you're subject to a superior constitutional government. That's where I was coming from with if the Cowichan, if they so decide to pass their own laws, maybe they can adopt your laws, maybe they can supersede your laws with their own. I mean, that's an open question, and I don't know.
Yeah.
That's sort of beyond the purview of the discussion of the case. But
Yeah.
that's sort of where I'm thinking that that I think separating those two issues, Aboriginal title being ownership, it doesn't necessarily mean that that your laws might be ousted. That's an open question, I believe, and it's probably one of the items that will be subject to negotiations in the next 16 months that we have left. So,
Thank you for your questions and your reflections. I do want to ensure that we get through as many questions as possible. So we'll go to the bottom mic here.
Thank you, and Julius Bloomfield, Mayor of Penticton. And I've also been in real estate for quite a long time, and when I first got my real estate license, which actually was a long time ago, but the first lesson we had was on indefeasibility of title, and that the owner of the fee simple title would be protected from any the results of any fraudulent activity on the title by the government, by the provincial government. And so with that, and under the terms of DRIPA, where DRIPA is the government departments that are responsible for enacting DRIPA are only the federal and provincial governments and no other level of government. And I don't believe that there's any onus on fee simple owners to be a part of DRIPA negotiations. So under those two statutes, is there what level of insulation for fee simple owners is there from by the provincial and federal governments?
Robin, do you want to take that one?
Sure, there's a lot to unpack there. I think one of the questions that arises in relation to the land title system is whether people who are adversely affected in the sense that their title isn't indefeasible have a claim against the assurance fund, and I haven't had time to think that through and research it, but I mean, the point being that the system, when it was created, was intended to be rock solid, and you could bank on it, and people did bank on it. And the court has now said, well, that applies in respect of every claim other than an Aboriginal title claim. And again, there's only been 2 other title claims that didn't involve private land. This one that now involves some private land. The rest are claims. They're claims either asserted or starting litigation, but not through. I think it'll be a period of time before that issue plays itself out anywhere other than potentially some of these, immediate lands in Richmond. But I think at the end of the day, this question about, to the extent that Aboriginal title is a caveat on the indefeasible system in the Land Title Act, how and to what extent can that uncertainty be reduced? And that needs to be tackled. On the DRIPA, I don't think it applies to individual people. It's a complex statute, raises a lot of issues. It's public knowledge. We're bringing a constitutional challenge. One of our clients, Pender Harbor, an area residents association, to the DRIPA, raises a lot of interesting issues. There will be definitely different views and lots of arguments on that one. But other than the reference, there's a couple references to DRIPA and UNDRIP in the Interpretation Act, but I don't think that was the primary factor that underpins this decision.
Thanks for those reflections. We'll go to the mic at the back, please.
Thanks, Jeremy Cardona, City of Victoria. I just wanted to start by thanking the panel. I've been to a lot of panels and conferences in my day. This is probably the most fascinating one I've been to ever. So bravo to all of you for... Really important and fascinating discussion. Just want to go back to the question of jurisdictional shuffle and maybe ask a clarification question, which is to whom, in fact, title was ascribed in this finding. And you all know more about the Cowichan tribe than I do, but it's my understanding that it's both a tribe, but it's also a government. It's a jurisdiction in a sense that possesses a reserve, it possesses a traditional territory. It is also a government. It's a people and a government. Was title ascribed to the Cowichan tribe as a group of people, or was it ascribed as a government? And if it was the latter, is it a reasonable interpretation of this finding that one implication could be that this, in a sense, becomes almost like an exclave of what we think of as the government or the jurisdiction of Cowichan, that it will no longer be a part of Richmond, it will now be a part of another jurisdiction, which I think you've been alluding to in some of your comments. Or were the courts clear in saying that this was not fact ascribing title to a government but to a people? If you could clarify.
Yeah, I could answer that. A great deal of time was spent on defining who the Aboriginal rights holder and title holder, because remember there's fishing rights and title. A great deal of time was spent in determining who the title and rights holder was, and that included expert evidence from anthropologists, oral history, genealogy, but at I'm not ducking the issue here, but I'm going to give you a legal answer. This was a representative action brought by 4 out of the 5 bands whose membership are the successors to the 11 communities who made up the ancestral Cowichan Nation. So that's a mouthful, and I know I've said that, but what in law, what one has to do is show who the present-day claimant's relationship to the rights holder for title at the time of the assertion of sovereignty, for other rights at the date of contact. In this case, in 1846 at the date of the assertion of sovereignty, and in 1792 at the date of contact, there were, according to the anthropologists and the oral historians, there were 11 communities whose membership today is in 5 bands who are the title and rights holder, and the representatives, I think I named the 5 at the beginning, who they are. But so that's the legal answer. The political answer I think that you're looking for is it's not an enclave or a separate government. It was a representative action, and the Cowichan Nation was the representative party, and now it's the Cowichan Nation who will enter into negotiations and who will become, through its representatives, the title holder and rights holder.
Okay, and just to clarify then, did the courts weigh in, though, on whether this section of land and water is still a part of Richmond, or did they leave that ambiguous?
They left that. They never said whether it was part of Richmond or not, except to the extent that Yeah, I mean, there's huge parts of the reasons where we talk about the constitutional underpinning and how the province and how municipalities own their property. But the court never says straight out at the end of the day that title land is no longer in Richmond, I guess is what you're asking.
Thanks very much.
Yeah.
All right. We'll go to the bottom mic, and if we're really quick, we'll get to the top mic before we have to close this out.
Hopefully I'll be quick. Natalia Malachuk from the City of Regional District. And to the extent that DRIPA needs to be considered subsequent to this decision, what would happen if DRIPA was revoked, so change of leave party, etc.? Can you speculate on what implications that would have either for moving forward in decisions of this, for this specific title or for others going forward? You had mentioned before that it was, that it would need to be considered in some ways. Thank you.
I don't think it would make any difference because the Aboriginal title and rights decision and the declarations were based on, they were supplemented, but they weren't based on that. So the legal basis for almost all of the legal questions here predated that.
David, it's fair to say that the success or failure of this particular claim that you brought would have nothing to do with the Declaration Act as adopted by the provincial government. It's non-consequential.
I wouldn't go quite that far
Is it-
because it does refer to it numerous times, and it relies in relation to the land title findings on the provisions inserted in the Interpretation Act based on the DRIPA. But as I said earlier, that was one of many things in the 3,728 paragraphs, and my point in raising that was not so much to suggest that this outcome was DRIPA driven. It was more to point to the fact that the court itself noted 3 things that were happening out in the world driven by the provincial government, whether legislative change under DRIPA or otherwise, that were at least deemed worthy of mentioning here. So I think that the relationship on this one is not huge.
I sort of agree with both that in this respect, the decision would have been the same without DRIPA, and this idea that indefeasibility is somehow raised in this case for the first time. There were decisions from decades ago that said Aboriginal rights and title were not registrable interests under the Land Title Act, and that goes back decades because they're pre-existing rights that are upstream from the creation of the province or Canada. And so I think there's a solid legal basis for the decisions in this case aside from DRIPA.
If I may add just one comment, I absolutely agree. We're agreeing probably more than people want us to. With this one caveat, that when that was tackled previously, it was not really in the I mean, it related to it, but you didn't have this square issue about Aboriginal title overlaying fee simple in the court finding it, so, yeah.
That's true.
Yeah.
All right, thank you. We'll go to the back mic, please.
Thank you. I'm Betty Anderson. I'm with the Caribou Regional District, Area K, which is the East Chilcotin. The Still-Cotin title land is partly in my area, and I've been a director back when this all came into being with the title acknowledgement, and it's been 11 years, and we have people in the area that, you know, are landowners that are around and in the title land that have never been compensated for their lands. That, you know, they spent their whole lives building up businesses and resorts and whatnot, and the government has promised to compensate them, and it hasn't happened, and it's been a very long time. So my concerns are about things like that with land, you know, with people's the livelihoods where, you know, they even just kind of, they can't really do their business. They're locked in, and that needs to be fixed. And then I guess that would be my concern for further situations like this, you know, and the taxpayer base and all that kind of thing. So thank you.
I appreciate you sharing your concerns. We don't have anybody from the province here who can speak to that, but I'll see if Robin has something he may want to share.
I'll speak to it because we're dealing with the issue. And, you know, I don't think it would be unfair to say that the manner in which the province has continued to regulate in respect of issues affected by but not directly on the title lands hasn't been super great. And we have a lawsuit that was filed on behalf of Silas Lodge and a woman, Karen McLean, who supported the Socotan in their Aboriginal title claim, supported it. She wanted to see that title claim succeed, but then said, wait a second, what is government doing to manage this and how is it affecting me? And, you know, both can be true. Both, you know, you can support the title claim and say, but wait a minute, you can't create a morass thereafter. You got to fix that. That'd be my words, not anyone else's. Unfortunately, Ms. McLean has recently passed away. So we'll see where that all ends up. But, you know, it's out there. It's a very live concern, and I get the calls all the time. But usually the people can't afford a lawyer.
Thank you for those reflections. It is 4:22, and David has a 5 p.m. float plane that we got to make sure he gets to.
You
So,
better run.
I am going to wrap us up here this afternoon and just say a huge thank you to our panelists for a very informative and thought-provoking session. Not only was it thoughtful, it was respectful dialogue, good debate, different perspectives were shared. From my perspective, I was walking over here this morning and listening to a podcast, and it was called "We Are Going to Have to Live Here Together." And I think that is very, very poignant. It was a different topic, but applicable here. And one reflection that I have from this morning from our resolution session, one of the special resolutions that was brought forward by a First Nations member to the Union of BC Municipalities, the Tla'amin First Nation, on supports for for the United Nations Declaration of Rights on Indigenous Peoples implementation. And the resolution was brought forward by the Tla'amin, and standing shoulder to shoulder with them was the Kathat Regional District and the folks from Powell River, asking for support from the province to be able to do this good work on the ground together, hand in hand. And I think that continues to be an important part as we navigate the uncertainty that gets risen as challenges come forward through the court, as they go through appeal, is to remember to show up in a good way and work with your neighbors. With that, I do want to note that in appreciation for our speakers today, UBCM has made a contribution and a donation to the Threshold Housing Society. Since 1990, Threshold Housing Society has been providing community support, understanding, and a place to call home for youth at risk. Their mission is to create a safe and supportive environment where every youth has access to stable housing and resources, standing firm against the systems that perpetuate harm and inequity. So thank you again to our panelists for being here and to all of you for staying out through the afternoon.